Good morning, everybody. I hope you're fresh for the second, hopefully successful, equally successful day of our common work. Before I give the floor to our keynote speaker and the chair and present them again, I would like to welcome our friend, James Stockstill, the senior advisor of the OSCE mission to Serbia. I mentioned him and Zorana and Dragana yesterday a few times because really they deserve to be mentioned with a great respect because their support is very, very important for everything what we have been doing since a few years ago and which we will continue doing, especially through this project and other complementary activities. So, James, thank you for coming. Would you like to say, no. Okay, okay. So, I have a great pleasure and honor to announce the visiting lecture of Professor Johanna Niemi from Turku University, Finland. And I will give the chair to my good friend and colleague, Professor Vuk Radović. So the floor is yours.
Thank you, Professor Vujadinović. Dear guests, dear colleagues, good morning. I have a privilege and honor today to announce our guest speaker, Johanna Niemi from Finland. But before I do that, I would like to share one personal, in a way, moment with you. A long time ago, in the year 2000, 2001, I started writing a book called Personal Bankruptcy. Most of you, at least from my faculty, know that. Back then, we didn't have those rich databases like Hain Online, like LexisNexis or Westlaw. So I tried to buy some books from the United States, from UK, but what was the problem? I didn't have any books from Europe. And I managed to find a couple of very valuable articles written by some professors from Europe. And one of those professors, which articles were very valuable for me, were articles written by Johanna Niemi sitting here. So in a way, maybe that will be interesting for her, that a young scientist in far away Belgrade was using at least a couple of her articles written in English. I must admit that my Finnish is a bit rusty. So those couple of articles were very important for me, not just because in those articles she showed me how personal insolvency looks in Scandinavian countries, which was very interesting for me, but also that she gave me a broader perspective, how Scandinavian countries have a special type of insolvency, individual bankruptcy in comparison with other, especially American or other European countries. So in a way, this is my way of saying thanks to Professor Niemi. As Professor Vujadinović said, Professor Niemi comes from University of Turku in Finland. She's a professor for law of procedure, insolvency law, and law and gender. She wrote a variety of books. One of the books that attracted my attention was a book, Criminal Procedure and Violence in Intimate Relationship. And as you can see, if you look at her biography, you will realize that most of her work, at least in last 10 to 15 years, deal with the topic of law and gender. So it is not, so she is highly respected in that area. And I will, in the end, just read from her official site what she said about legal teaching. Johanna thinks that the most interesting challenge to legal thinking comes from the feminist legal studies that have a close connection to gender studies. She thinks that all lawyers should be familiar with the main ideas about the importance of gender in our thinking and society, including the legal sphere. I think this would be a good introduction to the following lecture. Now Professor Niemi will give us a presentation on gender-sensitive legal teaching, aims, strategies, and examples. The floor is yours.
Dobra utra. Good morning, everybody. Thank you for these very nice words, which lead to me to memorize a little, to think a little bit back. And actually, my first article on law and gender was about gender aspects of consumer bankruptcy. This article has been published in Finnish, but also in Swedish, for the information of our Swedish colleagues, in 1996 in journal Rättfärd. Yes, I have been working with law and gender for a long time, and I have to say that it's a very nice day to be here and to be a Finn, because of the political things that have happened in Finland. Here is our government 1 year ago, represented by this troika, 3 key ministers. Here is our government today. On the left-hand side, you see our new prime minister elected last week, or actually this week, Sanna Marin. And all the 5 chairpersons of the political parties in government are women. And I think this also gives me a reason to say that at least today we have to leave the feminist tradition of complaining and analyzing and coming into conclusions that everything is wrong and be happy. And that's what I have been working with my doctoral student, Amalia Verdu, who is going to defend her thesis on the concept of gender in February. But first, a few words about why we have to be interested in gender and integrating it into legal education. And then I first want to remind you of our international obligations. I think all our governments and states have committed to the CEDAW, Women's Rights Convention, which is a very ambivalent convention, I would say, but has very ambitious goals. And one of them is that we have to introduce elimination of discrimination and also stereotyped concepts and the roles of the men and women at all levels and in all forms of education. And in particular by the revision of textbooks and school programs and the adaptation of teaching methods. I don't think there is a single country in this world which has implemented this article. And this commitment has been renewed recently in the Istanbul Convention on Violence Against Women and Domestic Violence in 2011. This is a Council of Europe convention covering all our countries, so I think this convention is going to put some speed into this process. But then I go to a more personal account about why gender is interesting and important. And of course, we think that it's important to enhance equality. I think we all agree on that, and the CEDAW Convention is very well devoted to this goal. Anti-discrimination law, especially anti-discrimination about sex, but also anti-discrimination law on sexual orientation, age, religion, and disability are hardcore European Union law, and I think that our lawyers don't do well enough in this field of law. But for me personally, I think it's very important that I want to teach lawyers with better legal skills of argumentation, especially. And I think that gender is a very useful tool for learning these kinds of skills. I think one of the very important things lawyers have to know is how to think critically. and that's something gender makes you do. And finally, I think we need to educate our lawyers who understand the nature of law, how legal concepts are constructed, and how other concepts are constructed, and gender and sex are primary examples of this kind of concepts. One more reason to teach gender comes from university pedagogics, which have been developing quite a lot during the past 10 years. And in university pedagogics, we now talk about learning outcomes. We don't talk about so much about teaching. We talk about what we think that the students should know and can when they have done a certain course or a certain program. Professor Bloom has developed a taxonomy of learning outcomes, which is a hierarchical organization of these outcomes. And at the first level, we have remembering. And I think that's what all our students and most of us, when we graduate from law school, when we think back, we think that we spent hours and hours in library reading the textbooks and cases and trying to memorize things. And those who haven't done that think that it's really, really boring. At the next level, we have understanding. And I think that's what we as law teachers try to promote. When we give lectures, we try to make our students to understand the principles, the legal system, how it works, what is important. I always say to students who fail in their exams that you have to go to the lectures and listen, because the teachers tell what is important. And what they ask in their exams, they ask what is important. It's not more complicated than that. At the third level in the taxonomy is applying. And that's what we also do in our teaching, but we also do it in exams. We make cases in our exams which the students are supposed to solve. Right. Analyzing, that's something we do, especially when we write legal scholarship. At the next level, we have evaluating. And this is something that many students and even lawyers say, it's not my task to evaluate the law. I just take the law as it is. I'm not doing evaluation. And I don't think that's really a good lawyer, because I think the lawyer has to be able to evaluate laws, interpretations, cases, to promote their client's case, or to make good judgments if they are court lawyers, and so on. But this is not something we really teach a lot. At the highest level in the taxonomy is creating. And I think that many law programs are built so that we somehow think that when the students come to the master level and start to write their master thesis, then at that point they are able to analyze, evaluate, and create. But do we really teach it? Okay, I will get back to this later. Now I will go through feminism as a scholarly discipline, not as a political movement. And my aim with this is to explain the concept of gender and its relation to different movements within feminism. In feminism, we talk about three waves. Any standard presentation of feminist studies, feminist scholarship uses this metaphor of three waves. I have made it 4 waves here because I think it's more clear that way. And it's a historical presentation in a way, but at the same time, it's also a presentation of things and tools and ways of thinking that are present and relevant also today. That something was before doesn't mean that it doesn't exist today. I think all these ways of thinking exist today, and they are all relevant for law and legal analysis still today. So when we are teaching law and gender, we can't say that there is one right way of doing it or one right way of understanding the concepts of gender and women and men and other genders. But you can use any of these, and when your students are writing their thesis, they have to explain what concepts they use and how they use. Well, first wave, and that will be very quick. The claim of early feminists in the 19th and early 20th century was that laws should be the same for everybody. They wanted to have the right to vote. They wanted to have equal rights in marriage and after marriage. They wanted to have equal rights at the labor market. And today, in most European countries, laws, that has become reality. The laws are mostly formally equal and gender neutral. There are some exceptions which may have practical consequences, maternity leaves. In my country, we still have the general military conscription for men, and so on. But these exceptions are quite limited. So that was the first wave. Second wave takes place in the 1980s, 1990s, 1970s even. Women and feminists started to ask, why did sex and gender neutral laws did not bring equality? And I'll get back to this a bit later. And the third wave was the understanding, that realization that we have very different women, we have different sexualities. Just bringing in women's perspective is not enough, because women's perspective may, if I exaggerate a little bit, may be the white, middle class, well-educated women's perspective and leave out others. I'll get to this, back to this as well. And then the fourth wave, which is very much related and intertwined with the third one, is that today we think that both sex and gender are socially constructed, not something that is a biologically determined thing. Okay, now we go to the second wave a little bit more, because that's methodologically still today very interesting and valid. So the question was that why do we still have inequality when we have gender neutral laws? We need an analysis. And we need to bring in women's perspective. In the feminist movement at the time, 1970s, 80s, 90s, women's experience was really important. It had to be brought into the culture. In historical studies, there are a lot of studies which, well, the tradition was that history was written from not only from the perspective of the winners, but also from the perspective of men. Bring in women's perspective. What was women's life like at different periods? We have a lot of statistical information about women's position in the labor market, taking who takes care of the kids and so on. And then we have the legal analysis. And you mentioned my book, which unfortunately is in Finnish and a little bit out of date today. criminal procedure and interpersonal violence, intimate partner violence, in which I look systematically through criminal law, criminal investigation, criminal procedure in the first court, district court, and the sentencing, and bring in the battered woman's perspective and find the problems and try to give interpretations that would serve better the victim's position. And this kind of bringing in the perspective is also used in other matters than just women's rights. There are a lot of books which analyze law from children's perspective. I think in most cases the point is to bring in a perspective of people who are in a very vulnerable and oppressed position and who have not been in the center of the regulations when they have been done or when they are implemented. This wave is full of different theoretical schools within gender studies, and I'm not going to go in detail to all of these. Catherine McKinnon is very famous with her sort of biological determinism. She's saying that women are oppressed because of sexuality, that rape law is one of the most, or rape is the most oppressive mechanisms, and which doesn't mean that all men rape, but all men benefit from the situation that some men use sexual violence. I think this view is pretty harmful. First of all, it necessarily blames all men for something that some men do, and that I think is totally wrong. There are so many more men who don't use violence than men who do use, that any kind of collective guilt, somehow provoking a collective guilt, is totally wrong. When I'm talking about these things, I notice that sometimes men in the audience, they get this feeling of collective guilt for their fellow men. And no, that's wrong, and it's very harmful for any feminist claims because we need those men who are for equality to work with us. Structural gender orders. At this point in the 1990s, sex and gender became different concepts. Sex was used for biological sex, gender for social and cultural gender difference. And in addition, Gail Rubin and Yvonne Hirdman in Sweden and most of the Swedish feminists, Eva-Maria Svensson and Åsa Gunnarsson in law, very much underline this idea that gender is not only the social and cultural equivalent of sex, but it's also about power. It's also about the power structure in society, which so far has put men in the more powerful position than women, and this hierarchical relationship is produced in social structures, including law. It's produced in culture. It's also produced in interpersonal relationships. And this is a very valid point still today. The second wave has produced a lot of discussion about similarity and difference. Are men and women similar, or are they different? And this wave criticized especially the first wave for assuming that men and women are similar, and only we abolish discrimination, everything will be fine, and treat them similarly. And also, the structural gender order thinking, there is a certain idea about similarity. Just we abolish the power structures, everything will be fine. Whereas biological determinism is very much built on difference, and also other, well, from this thinking, the sexual difference sort of started to take position within feminist thinking. And it's still today, it's very much a discussed issue, which is how we should go. Second wave is very relevant for law. I already mentioned CEDAW Convention, which is really committed to promoting equality, and which really has the idea that equality doesn't come automatically by making laws similar for everybody, but it needs active work, active political work, active legal reform. And the European Union anti-discrimination law is a good example of that. The directives include the concepts of direct and indirect discrimination, and the idea is that to abolish discrimination needs genuine commitment and genuine work, and the European Union has also had a lot of soft law documents in which active work to achieve equality is very much present. And then, of course, all this has become a reality in national laws as well. So now we come to the third wave. And the third wave comes the critique against the second wave feminism, arguing that women are different. They are different according to their social position, according to their family relations, and they are different according to their ethnicity. They are different according to their sexualities. And this is all something that should be accounted for, and we can't really start from the assumption that all women are different. Today, we talk about intersectionality, and I think that's something that you really need to work with, because that permeates all the gender discussions today. Often intersectionality is understood that it's an intersection of sex or gender and race and ethnicity. But it's not only that, it's also a question about sex and gender and age, for example, and we need to be sensitive about how our laws treat women, younger women, elderly women. Is that equal? How does legal regulation affect different groups of women? Intersectionality comes from 1990s, from Kimberly Crenshaw's analysis of why colored women in the United States were always in the worst position of all groups, and discrimination law wasn't very good tool to promote their position, because if they were because there was very often no comparison. There was no woman, there was no colored man who would be working in the same jobs as they are, and yet from all these groups they were always worst paid, in forced working conditions, and the poorest. We have strong anti-discrimination law at European Union level, but from 2000. The limitation of this law is that it's limited in scope. it's mostly working life and work-related social benefits, social security. Sexual orientation has been a topic in the European Court of Human Rights during the past 20 years, and from the start they didn't really accept sexual orientation as a ground of discrimination, but later it has found its way into the jurisprudence, and now for the same-sex marriage, the position of the European Court of Human Rights seems to be that the national legislators have to do something to protect people who have a different sexual orientation than non-heterosexual people, you can say so. And then the European Court of Justice seems to have the position that once we accept registration of non-heterosexual couples, the national laws and authorities cannot discriminate people on the basis of what sexual orientation their partner has. But I think we have here people who are more into anti-discrimination law and can continue the discussion from here. And then I come to the fourth wave, which is a very interesting one. From philosophy, social sciences and cultural sciences, we draw the idea that concepts are socially constructed, that there is no authentic concept of table. It's a very typical example we use. But we have a social contract that we use the word table in a certain meaning. It's not just pieces of wood and metal, but it's something that has a function and meaning. And that's something that applies to all concepts, all very, very practical concepts like the table, but also the more theoretical concepts like gender. And with gender, it's very simple. It's something that if it's gender is a social equivalent of sex, biological sex, it's all something that is socially constructed. And you can discuss with your students. They are able to come up with examples how in social practices and language we construct gender identity. Think about all how we dress, how we exercise, how we try to form our habitus, what we do, how we behave, and so on. So that's fairly easy to take. But then the next step is that sex is also a social construct. I have participated in discussions in which doctoral students have had a fierce debate on whether there is a biological sex independent of our language. And for a long time I was thinking, okay, I don't care. There is so much in social practices and even law that is constructing gender that the question whether what's our position or what we think about the biological sex, which is somewhere there under all this social, it's not really that important. But then there was Kasten Semenea, who won the women's competition in 800 meters, and there was a huge discussion about her sex, mostly run by male sports reporters. They were wrote numerous articles about what is her sex. Well, okay, we let the medical doctors decide. We put her into biological tests. And then the medical doctors come out and say, oh, we can't tell. We have no answer to this question. And after that, we have realized that there are surprisingly many people who feel that they are living in the wrong sex, and they want to correct their sex to the one that they experience as the correct one. There's a lot to this discussion, and we can go into it if you want later. Then we have also intersex, which probably is the case with Castansemenea, that they have some of the sexual organs of both men and women. In our Western countries, the medical profession, medical doctors try to correct that right after birth. And sometimes the correction goes right, and everybody is okay with it. But sometimes it goes wrong, and the person later experiences that he or she is living in the wrong sex. And the intersex, we don't know how many people we have. And in less developed countries, the medical profession does not, the medical checks of the babies are not as advanced in our countries, so probably there the people are let to grow as they want. And this is also one of the things that really challenges the idea that sex is somehow biologically non-questionable thing. Actually, it is a social construct. We have socially decided that being a man or being a woman is very important. And it's so important that everybody has to be given the biological sex in the beginning, and then it will determine a lot of things in their lives later. So now I will go back to teaching. In curriculum, I think the ideal would be that issues about sex and gender would be mainstreamed in all legal disciplines, in all legal teaching. Well, I live in the reality that no, it hasn't happened. So, what can I do? And now I will go to the part of my presentation which is about examples. There are strategic choices. One thing that I have been doing during the last almost 10 years is that I try to introduce a piece of gender and law in the introduction course with the first year students. I'll get back to that in a moment. We run for 12 years, we run at the University of Helsinki a course called Violence, Gender and Law, or Law, Gender and Violence, as an elective course. And then I have been also with Amalia Verdu, I've been doing this law and gender courses, some sort of introduction to law and gender as an elective course. And of course what you are doing here, the master in law and gender, I think it's a wonderful endeavor, wonderful really. And finally, I think the final goal would be mainstreaming gender in all law teaching. So then we have to think, when we start to think about these courses and reforms, we have to think about what is the learning goal, what we want the students to learn. And for me, it's quite clear that the introductory course, it's just about waking up, awareness raising, making it accessible. Then we have a lot of content-based law, and especially anti-discrimination law is something that we need to teach our students in elective courses, and of course labor law should be a place where they teach anti-discrimination law. Then the legislator should make a gender analysis of all laws. At least in Finland there is a guideline that every law that is presented in the parliament should have a gender analysis. Usually this gender analysis is that long paragraph which says that this legislation may or may not improve equality, especially for women. That's not a gender analysis. We should, as law teachers, produce lawyers who can do a gender analysis, or who at least can do it with the help of social scientists. And then I also think that we should produce lawyers who can understand that the society has a number of gender structures that they have to understand. Thinking about, for example, marriage. It's a legal institution, but it's a very important social structure. In my country, marriage law is gender neutral, but it's based on a very clear structure or structural thinking about marriage, that marriage is something that you do when you are 20-something. You stay with your spouse, get children. One of the spouses, without any gender, takes mostly care of the children, and one of them takes care of the economy of the family. Then something happens, either you divorce or a spouse dies, and then you split the economic entity. Look around you. Who lives like that? A minority. There is a wonderful passage from the European Court of Human Rights about gay rights, in which it says that, well, gay people are equally capable of long-lasting and caring relationships as heterosexual people. Look around you. I don't think heterosexual people are doing very well in this respect. Okay, let's go to the concrete courses. I'm a bit proud of this. I made an initiative that I want to give a lecture of 2 or 3 hours to the first-year students quite in the beginning. My aim is that I want to make talking about sex and gender politically correct in the law faculty, because it's not. Legal education is 5-year brainwashing that law is objective and neutral and gender doesn't play a role. And if you catch them in the beginning, then you maybe shake that belief a little bit. Doing that, I have been quite happy with the course, except for this year. There are some things you have to do, and one of them is that you have to avoid some kind of opposition of men against women, because that doesn't go down well. It doesn't work. Not the female students. They have just made their way to law school. They are really good. They are really equal. They have never been discriminated against. They think that life is ahead of them. They are happy. And then comes a teacher. Well, you know, just a couple of years when you graduate, you will know you won't get the jobs. They always prefer male colleague. And then you get kids, and you are working on a time-fixed contracts while your peers, males, they get permanent contracts, and then you stay at home. It has an effect on your career. It has an effect on your pension, retirement, and so on. Who wants to hear that when you are 20-something? Nobody. You have to avoid this. And then, at least in Finland, I don't know if this is true for all countries, you have to take seriously men's concerns, and that's where I failed this year. They clearly wanted to talk the military conscription. They experience it as unfair discrimination against men. And I admit, it's true. It really is. It really is true. But I wasn't able to discuss it in the right way with them. What has helped me a lot is that I bring in the discussion also ethnicity, sexual orientation, gender identity, a little bit of age and disability as well, but they are not really interested in those. But these ethnicity, sexual orientation, gender identity, when they talk about that, they don't talk about themselves. And especially for women, it's very difficult to talk about, I want my rights. I'm oppressed. Admit that I'm oppressed and I want to work for my rights. It's really difficult. But when you are allowed to talk for the rights of other people who are oppressed, women are pretty good, especially children. I do the same 4 waves as with you. I use a little bit more time. I try to make them discuss. I always start the lecture with asking them to tell me where they think gender and law interact. What are the connecting points? And they produce quite a lot of relevant issues that then I take up during the lecture. Sometimes make them do pair discussions. If they are not willing to come forward, then they talk like 1-to-1, and then I ask, what did you come up with, and so on. And then we try to have discussion as much as possible in a big lecture hall. Sometimes I have a problem that male students are much more active in participating in discussions, and then I try to activate the female students. Once I had to say that now I'm not going to give the floor to any male student before a female student has said something. And then the male students started to push papers to their female colleagues. Ask this, ask this. Learning diary as a form of examination, I have found that it's very useful when you have a mass course. Because you can't do, it's difficult to do a very individual examination. And learning diary, I've used it with this introductory lecture and also in this law, gender and violence course, which was also a big one with more than 100 students. The most important thing about learning diary is that it gives the students possibility for reflection about the issues that they have learned. And you have to remember, because everybody has a personal relationship to sex and gender. And everybody has issues that they don't want to discuss in the public room, but they need room for reflection over that. And especially in the law, violence and gender course, when you have more than 100 students, you can count on that there are a couple of them who have either experienced violence themselves or who have somebody who is very close to them who has experienced violence. And they are able, in the learning diaries, they are able to reflect on these situations and their own attitude, their own actions, behavior in that. And one good thing about learning diary is that students in the law faculties, they experience a lot of stress. With the learning diary, you can downgrade the stress level. My idea with the big law and violence course has been that all pass. Everyone passes with the lowest grade. During 12 years, we failed 1 student. And then he took a long time, well, I think 2 years after, he took contact and said, I know why I failed. Can you give me a possibility to make a re-examination of the case? Now, through my girlfriend, I have learned a lot about these things. And by the way, girlfriends are very important in teaching sex and gender. And then he was able to do a new writing and pass the text. But of course, if you want to pass the course with the lowest grade, you don't achieve the very ambitious learning goals in the Bloom's taxonomy. It's not, to get the lowest grade, it's not enough to just state the facts, because they are able to use any materials they want with the learning diary. But at least we require that they have understood what we are saying. And then to get a better grade, you have to be able to apply what you have learned. And one way of applying is that you discuss what you learn with your previous knowledge. Everybody has previous knowledge of sex and gender and violence. And then to achieve the higher grades, you have to be able to analyze and evaluate, use the sources, and so on. And some of the students are even able to create some kind of a synthesis of what they have learned. And it's really nice to read those learning diaries. Then we go to the special law and gender courses, which you are working with. And I think that it's very important to think about what are your aims and what is your target group. And there are two kinds of elective courses. And one of them has the aim to give for the law students, especially usually female students, nowadays more and more non-heterosexual students, who need a space in the faculty to reflect over their thoughts about gender and sex and feminism. They are already informed to some extent, but they have never found during their studies a space for expressing their ideas. And these are wonderful courses. They really have ideas. Once I had a course where they wrote essays, and all the 15 students, everybody came with a topic. One said that I want to write about sex-selective forced abortions in India. This is something I have been thinking about for many years and wanted to write about it. I really want to write about this. Okay, great. You have to have this possibility. But then there is another target group. And that's all students. And then your aim is that you want to get students interested in equality and you want to promote gender sensitivity. And that's not easy. But I think we have to take a challenge, because if we only take the already converted, it's not enough really. And then the first thing you start with is the naming of the course. And I mean, even if you are working with a master program for already converted, you probably want to also design courses that are attractive for other law students as well. Mixed courses, I think, would be a very good solution. But there are many students who don't come if you have the word feminist in the course title. Just forget it. Even sex and gender are a little bit dangerous. Law, gender, ethnicity, they were all women on that course. Gender, law, and violence, with that we had a very mixed student body, and the reason was that we cut the course in law and sociology, which was a mandatory course, they could make one part of that course by doing this law, gender, and violence course. So that's why we got so many students, and many of them had no previous idea about sex and gender. But that was kind of good topic because it didn't usually, it didn't provoke much of opposition from the students. Some yes, but we had different lecturers, and there was especially one male professor who was talking about domestic violence as a gendered phenomenon. He had interviewed both women, mostly women, and he was so feminist, and he said everything that we female lecturers said. But the students were always, after his lecture, they were like, oh, this is great. Leo is so good. Leo Nyqvist is his name, by the way. He is really good. I had always my lecture after his, and it was really challenging. The introduction to law and gender, we have changed the name to Challenging the Neutrality of Law. At the same time, we have upgraded our learning goals a little bit. We emphasize more the critical thinking that we want to teach, and then I tell something about this course. Our goals are to make the students understand that law and legal principles can really work for different outcomes and interpretations. Well, that's basically something that we all know and they should know, but somehow some of them don't know. And then we want them to understand that knowledge is constructed and interdisciplinary, and it's constructed in social processes, and that power of law is very important in the social construction of our society, and it creates all the time inclusions and exclusions for different persons. And also we use sex and gender as a tool. You might say that it's not right to use sex and gender as a tool, but it's an aim in itself, but we use it as a tool, and we use their experience about sex and gender, and we provoke them to think about what it is gender. It's kind of easy to think about what is one's gender, the social role. But then it gets a little bit more difficult to think about what is the sex, what makes the sex, what makes you to say that you are female or male. And then we try to proceed to the questions that how are sex and gender constructed in law, and are they constructed in law, and how do you know that? And in this course, the most important thing is to create an environment in which students can express their views. The teacher has to be very careful in not imposing her or his own ideas about law or legal thinking, and not political views, of course, not at all, so that the students feel that they can really reflect on their experiences and an understanding of law, and that they don't have to be afraid of that they give wrong answers. In this course we have, skip this, in this course we have had International Student Body. It's a course that has been in English all the time, and it's offered to exchange students, and we use their experience. They are supposed to tell about the laws in their own countries. They make little presentations about the laws of their own countries, and especially during the last years, those laws that challenge the concept of sex and gender have been discussed quite a lot the examples that I have taken already up. And then, of course, we use all the typical law and gender examples. We use group work. Then they present what they have, their group work to other students. We use reflection papers. When we have read an article, they are supposed to write one A4 paper about what kind of things this paper provoked. Catherine McKinnon especially provokes a lot of criticism. Then we have used, we have gone through these gender theories, which also we think we look at how they relate to legal theories. And then we have had a classroom exam in which they know that these theories will be on a topic, and then we ask them to implement or apply these theories into one legal institution. Like I always formulated the question like, there is a country which we call Moominland, and this country is now planning to introduce a gender-neutral marriage law. Can you evaluate this marriage law from different feminist theoretical perspectives? And then always they have a different topic that they have to evaluate. Essay is also a possibility for examination. When we come to law and gender program, I think that the learning goals have to be quite ambitious. And I think that one of the main goals is that the students will have a broad theoretical understanding of sex, gender, and sexuality in law. And they have, and then because now we have to underline the practical skills they get, I think they should have the basic ability to do gender assessment of laws. And to be able to analyze legal structures as gendered structures. And if I have some time still, I would like to say a few words about mainstreaming. At the University of Turku, we are now starting to work for the curriculum for the next 2 years. And our equality board decided that we, they had a seminar with trans people. And this seminar really was an eye-opener, because the message that came through was that these people don't feel that they are welcome in the university community. They are ignored, and they don't they don't even find toilets. That's how we got to the newspapers, that we want to abolish gender-specific toilets. But it goes further than that. It's not in the content of any discipline in the teaching of the university. So the Equality Board decided that we want every discipline to think what are the gender, ethnicity, and disability aspects in their curriculum that they should recognize for the next 2 years. And then we wrote some guidelines in which we say that you don't have to do everything, but you can pick up what you do and what you look at, and what is relevant, because different things are relevant in different disciplines, and what is possible. And here I have some examples. Textbooks. First of all, do you have explicit sex or gendered examples in the materials? In my field, procedural law, we used to have, in exams, we always have cases, and we used to have cases in which Albert A, Bert B, and Dick D used to do different transactions and ended up in the court. I changed my examples, my cases, so that there was an A, Bertha B. and Cecilia C., who did all these crimes and things and ended up in the court. Students had a very easy task in knowing which case I have done. And in the materials, when you have, are all actors men? That's the first question. And if you have women, are they in stereotypically female roles? Are they victims of rape? Always. Very depressing picture of women. Are there implicit gender stereotypes? That's the next question. Is there an advertisement in a journal looking for a young and dynamic young lawyer, which means that we are looking for somebody who has no responsibility for kids, no risk of getting pregnant and being on maternity leave? That's the implicit message. In contract law and in procedural law, a typical example is a sale of car. I changed it to example that a dentist and A buys dentist machinery and it's wrong, and then they end up in court. Do the materials cover all relevant points? Is violence against women included in criminal law, procedural law teaching? Actually, no. Are questions about parental leave and pregnancy discrimination covered in social law and labor law? I don't know. And finally, who has written the textbooks? We asked when we made 10 years ago at University of Helsinki equality study, we asked the students and teachers, have you ever paid attention to who men or women have written the textbooks? It was a standard question we picked up from some kind of institution of educational development institution. We didn't make up the question ourselves. And this provoked angry answers. One of them was that, well, the whole point was that does it really matter? And one of them was that does it really matter if it's male or female or orangutan? It's the content that matters. But have you ever paid attention to who has written the textbooks? Organizing education, there are some issues as well. How do you, if you make group work, who and how the students are divided into groups? Is a gender balance in the group something you aim at? Or do you want on purpose have one gender groups? Can you take somehow the students' age or ethnicity into account? Probably not. But it would be, we have some more mature students. It would be very nice to integrate them with the young ones because they have experience that can be useful. And then who speaks? How are women and other and women are not minority anymore, minorities given floor in the discussions? And if not, what can you do to encourage them? The simple solution are peer discussions, that you put the students to talk about something one-to-one, and then after that you choose some of them and say, what came up in your discussion? And then you can see that you also ask minority students. And, well, how to create a constructive atmosphere. It's not easy. And then we, of course, have this question that how look at the gender and ethnicity of the student body. We have women now, but do we have minority men, minority women? And what can we do to encourage them to apply. In UK, they talk about outreach, that universities should go to areas where minority populations live and somehow try to make the possibility of university education more appealing and accessible. For gender courses, course title, I already mentioned, what you say in the course description is very important. And then we come to the most important or very important question about professional identity. What kind of professional identity we are promoting to our students. My daughter is a social scientist, but not a researcher. She's working in practical life. She has studied political science and social policy. And this year she took an introductory course to law. And her comment was, this material, textbook material, starts with the promotion of the lawyer identity as a very special, specific, talented lawyer profession that has a very privileged knowledge in the society. How can you do something like that? What other profession has that kind of self-image? Yes, I think we should look at ourselves. In Finland, the two main lawyers' organizations are called law men's organizations. It's 35 years ago I graduated. I still don't identify with law men. There has been some initiatives to change the names, but no, it's historical, it's the tradition, and so on. I think the students' organizations are very important in the construction of professional identity. In my country, the students' organizations are very autonomous. We can't really interfere with their activities, but I think that they have a lot work to do before they are really promoting an atmosphere that really includes all kinds of people. And finally, I want to say that education is a political act, and legal education perpetuates the legitimization of power. But it could also be used to transform power structures, and I think that's how we want to change it. Thank you.
Thank you, Professor Niemi, for this. Thank you for this very interesting presentation. Although our time is up, I think it would be a pity not to have at least 10 to 15 minutes discussion, because this was a very provocative presentation. So since we have here a lot of people who are interested in these fields, I ask you to give some comments or ask some questions related to this topic.
Because the girls are very, they are, just as you said, the girls are very hardworking, successful. They see themselves as lawyers, are really focused on the work, and they are not going to be discriminated. But what we did is that we worked together with a researcher. He's from English language, actually, but he has done a lot of research on stereotypes. So we have done examples where half of the group get the example with like a male main person, and it can be, we have tried it in labor law and also in a case around custody of children. So half of the students hear the case where the main person is male, and the other group hears the case when the main person is female. And they don't know that we are actually looking at gender issues. They think that they are just solving a case on custody or something. And it always turns out differently depending on which, if there was a female or a male person telling the story, so to speak. And we have exactly the same story because there is a language lab where they just change the voice to a female or male voice, so they hear exactly the same. The only thing is that is changed is that the voice of the person telling the story, and that is a very good eye opener for the law students because they notice that they are not neutral to which sex or gender the person has who tells the story. So I think I would recommend that actually to you because it's a very interesting outcome.
Yeah, thank you very much, Professor Niemi, for a very interesting and very rich presentation. I would just like to go back to the beginning of it and to the 4 waves of understanding and development of gender and relationships in the society. And I would like to ask you, you have pointed out that in the 3rd wave we have acknowledged that actually there are different types of women, different sexualities, different ethnicities. So what is actually the substantial equality which we are targeting, which we are looking at? If there are no right answers, which I agree with you, so, and if gender is fluid as it is. So I'm a constitutional lawyer, so I'm concerned with the electoral quotas for women. And for example, we can see that they have not significantly changed. They're actually perpetuating the present power structures. So is it a long-term process? I mean, the politics, they haven't introduced, I haven't seen actually, in Serbia at least. We have a president of the Constitutional Court who is woman. We have the president of the government who is woman. We have the president of the parliament who is woman. And I haven't seen anything changed in the way they do their function in comparison to their male colleagues. So, and we have other, we have legal electoral quotas for women to enter into parliament, to have at least 1/3 of the parliament composed of women, so on and so forth. So what is actually the substantial equality which we are targeting? Because you said yourself that you know, there are different women. This applies also to ethnicities. You know, the fact that you will have some ethnicities present in some board doesn't mean that they would actually protect the rights of ethnicities. You know, they actually may only mask the situation and serve decorative purposes rather than to be functionally useful. I don't know if I've been clear enough.
Well, I think that there are quite many aspects to this question. And first of all, to think about the different non-heterosexual minorities, that doesn't necessarily affect the quota thinking if we accept that, like for trans people, they are in the quota for which they feel that they belong, if they have the possibility to correct their sex. Then for other minorities, it's very difficult to say what is the impact of women's increased presence in policymaking bodies. I don't think the Serbian. You want to say something to this? No. Yeah. Yeah. It's the Serbian. I don't think the Serbian experience is universal. I think that the presence of women in policymaking bodies has done a lot of change. For example, in parental leave, maternity leave, working life regulations, social security, social protection laws. For example, in Scandinavian welfare states, they are products of parliaments which have had both men and women, and also we have had a lot of women in the government, and also in the civil servants working for the government in the policy making, yeah. There are the quota regulations in different countries. They are very, very different. And there has been a lot of discussion about how do they really, what kind of goals they really protect, and what we need start to be at the point where we need the quotas to preserve for men a presentation in many bodies. But but we can't really say that generally men or women tend to pursue different politics. There are conservative men, there are conservative women, there are progressive men, progressive women. But yeah, there are also differences. But maybe.
Good morning. Talking about this same problem or results on quota regulations, I agree with everything that Dr. Niemi, Professor Niemi has said, and the impact of the quotas is not only, depending on the country, of course, but it is not only in the political representation. We are talking about union representation. We are talking about models of visibility for young children. So, because the main problem in this gender issue in general is the how do we accept the way of being women or being men? So, if our children have in mind and they grow up making visible different positions of men and women instinctively, they will grow in equality positions. The problem is that if we didn't have this quota, you can be in favor, because this is a very deep debate anyway, but at least they develop the possibility for women to be in decision-making posts. And this has led, as she will have just said, that regulations in labor market related to balancing family and work life, to parental leave, to children policy making and things like that, has been led mainly by women and not by men, because this is not a matter of interest for men, and that's reality. Okay, in my investigation in women unionism, you can notice perfectly, I'm talking about the experience of women. We are not talking about statistics. We are not talking about how many women are in position of power in, no, I'm not talking about that. I'm talking about how women perceive their relations in their organizations. And when we talk about organizations, we can be talking about university, we can be talking about government, we talk about municipalities, we talk about the college of law and I don't know what. Okay, and the position of women in every organization is absolutely determined by gender. And when you listen to the experience of women in daily life, I don't know about you, I mean, women here, but as she said, in the dynamics of the classes, of the lectures, you can perfectly find how normally men intervene much more than women. And normally we listen more to women. But that happens in the nursery also. So it is just a question of education. It's a question of how we normalize power relations in every aspect of our lives. So if we start to look at models of women with positions of power, I'm not talking just power relations, I'm just in every ambit of the daily life, not us, because we are just a lost generation, I think, but the next ones, we will grow up like more equal persons. Okay, so I don't know if I explain myself because my level in English is not the very best, as you can see, but I think that the quotas reflect or is a means to achieve models that help the next generations, more or less. Yep.
I would also like to add that I go back to my negative feminist identity, that it's also a question about how we understand expert knowledge. It's very typical for, even in Finland, for people who are looking for persons to a professional body, committee or working group or something, to say that we are proposing this and this and this, and they all are men because there are no competent women. Come on. Our universities have for 20 years produced more female graduates than male. You can't say that there are no competent women. Call me. I can for almost any function I can propose 2 female experts. But it's so typical still today that people are somehow depicting expert knowledge as male. It's almost impossible for me to understand that it still happens today. But I confront this so many times, and I'm so fed up in saying, hello, in this working group, could we have 1 or 2 women? Not even the 40%, which is the quota in Finland for these kind of professional bodies, but at least 1 or 2 women, and I can propose competent women. And I'm so old and in a position that I can say that, but I know that it's very difficult for young women to say because they very easily they understood that they are sort of trying to self-promote themselves. So yeah, I think I love quotas because it takes some of the burden from my shoulders in proposing and in trying to say that we have competent women.
I would like to share with you a drastic example for what you just said on how gender-neutral law does not mean the equality in reality, and how it actually needs a clear structure of thinking in order to guarantee the equality between men and women. Actually, I did a research on procedural law, and procedural law is usually neutral. It is also gender-neutral. And I did a research on small claims litigation proceedings. Small claims are, it is a litigation proceedings in Serbia, it is a litigation proceedings in all other comparative jurisdiction that I compared Serbian law to. However, I came across to the example of the Kingdom of Jordan, and the situation is completely different. Namely, in the Kingdom of Jordan, a woman gets imprisoned because of the debt of her husband. And how does that happen? The law does not say a woman goes to prison. The law says a person. But in reality, it is always a woman. And now there is a report from the UNDP or some other international organization, I forgot about that, how to deal with this problem, since the woman needs to spend 3 months per year in prison because of the debt of her husband every year until he pays off his debt, and there is no way that she can get out of that, even though the law is gender neutral and the law says that a person goes to prison. In reality, a woman always provides some kind of security for the debt that her husband made for the family, usually, because it is all a small claim. And even when it comes, in the case of the general amnesty, she remains in prison. Why? Because it is not a crime. It is a small claim. So I think that this example proves that really the clear structure of thinking, what you just said previously, is the precondition for the gender equality, and there can be a gender-neutral law, but we need the other way of thinking when applying it.
Okay, maybe we better stand up. Thank you for interesting lecture. There are some points I would comment on and discuss. The first, you made reference to a neutral environment. This is something which sounds strange to me. I think that dealing with gender law is already a political choice, as not neutral one. Neutral law does not work. So if we decide to engage in anti-discrimination law, we're already taken a decision, which is an ideological decision. And as you said at the end, law legitimizes power, but law can change power. That's a political attitude, and it's a logical one. And I think we need such a consciousness. When the presidents of the government or the European Parliament do not represent something which is behind them, their activity is weak. I want to remind that the first female president of the Italian chamber started a speech saying, I know that I was charged of the rights of women that fought for women along these years. So she represents not herself, but rather persons which were not political neutral actors. They were hacking to get some hams. And I think that what we need is such a consciousness, where we took a political choice, and the ham is to transform society. Otherwise, political actors represent just themselves. And if they represent themselves, they are always weak, no matter their ideas. The third point, which was clear to me, you made reference to gender issues and ethnicity issues and so on. I don't understand if the approach, scientific approach, is the same or not, and this is what I think. And furthermore, if you make reference to different cases of discrimination or cases of intersection between gender matters and ethnicity matters. Thank you.
Thank you. Marko Davinic, Faculty of Law, University of Belgrade. First of all, thank you very much, Professor Niemi, for this interesting and thought-provoking presentation. I will have a very short comment because I know we are in a hurry. You mentioned at the end of your presentation that two main legal institutions in Finland have in their titles lawmen's organizations, something like that. Of course, it is important to be gender sensitive, but I think that we should be cautious not to be oversensitive, and I will give you one, I think, good example. Institution of Ombudsman is Scandinavian one. It has been existing in Sweden for the last 210 years and in Finland for the last 100 years. In some countries, they started to call this institution ombudsperson because they think it's more appropriate. But, you know,
210 years of tradition is also very important. And when you say ombudsman, all people around the world, most of people around the world will understand what this institution is all about. Thank you very much.
Thank you. Thank you all for this fruitful discussion, and we are grateful to Professor Niemi for coming here and giving us her lecture. Thank you, and we hope that you will come to Belgrade again. Do you have some comments?
Well, if you allow a little bit joking this ombudsman comment, so maybe for the next 100 years it should be ombudswoman, and everybody would know what it is. But yeah, I understand that there is a value in preserving traditions, but I think these are things that we should discuss.
So, 12 o'clock, just a second. Hello? So we will have a very short break, excuse me, just until in 6 minutes, until 12 o'clock. And then we will share the... Oh, I'm sorry. That's good, that's better. 11:30, and then we will work, let's say, 45 minutes in the groups from 11:30 to 12, 12:15 or 12, we will see. And then we will proceed with empirical survey tool analysis. But we have to be strict because the time is running away. So please come back at 11:30 and we will work